that were cited, the Nalukoola, the Chintu Brandon, in those cases, it is the deponents of the two versions of the affidavits who had to come to court. And the guidance of the Supreme Court is that they must be cross-examined. In all those cases, some of which I happen to be part of, it's the witnesses that pointed out to court that no, it is the other lawyer, it is the other person.
What about these two? Hassan and George.
Most obliged, my lord. Most obliged, my lord.
Those two.
And those two, my lord, my quoting of Rule 17 was introducing me to the two. For example, my lord, Maumbe George. Maumbe George William, my lord. Maumbe George William, my lord, is a very interesting. He's a very interesting guy. My lord, Maumbe George William has deponed an affidavit. And my lord is saying, I've never deponed any affidavit. My lord, I can't answer that question because I wasn't there. I'm not Maumbe. My lord, there is. Yeah, there is. However, as to whether he swore it or not is for Maumbe to come before court. And that's what all those decisions cited. My lord, the one in the petition or the one?
One by one.
What's the plan?
The one for the petition.
What's the plan?
This is for the petition.
Yes, my lord, that's for the petition.
And what about the first respondent? Yeah, among the witnesses as well.
Yes, my lord.
So now that you have yes, I know. Yes, my lord. Now that you have the document, you have one for the petition and you have one for the first respondent.
Yes, my lord. My lord, I would like first of all submit that the concept of recanting witnesses as it is coined under our jurisprudence is not expressly provided for under the laws of Uganda. Like the word recanting witnesses. Be akin to recanting witnesses is under section 153 and 154 of the Evidence Act. And those are the hostile witnesses. And how are they treated? My lord, I'll come there. But let me exactly go to Maumbe. My lord, Maumbe is a very interesting witness. And Maumbe is one of the reasons why the Supreme Court has guided that when court is faced with these scenarios, because they happen for so many reasons, before you even inquire to apply section 154(2), whether it is the opposite party that has bribed, coerced, induced, or done what, court must ask itself, was even the first affidavit, if any, acquired under any better terms? And that is the duty that the Supreme Court places. My lord, page 22. It's highlighted. paragraph 4. This affidavit believed says a lot about the way some witnesses are made saying affidavits during election petitions. It contains very serious allegations about the parent, and one would have expected the deponent to be subjected to rigorous cross-examination. He was not. Now, before court can be able to say which of these, because for example, Maumbe George Williams, my lord.
So this decision of the Supreme Court, was this also a case where the witness was on both sides?
Most of like yes, my lord. Participatory material. But for Maumbe George, it's more interesting, my lord. And it would be very interesting to have the same person before court. Because it says, I never deponed an affidavit for the petitioner. I never at all met the petitioner. I never talked to the petitioner. Even on the voting date, I did not vote because I was not in the constituency. But this is a witness that has been presented by the petitioner. And my lord, how does Maumbe come? Maumbe comes through another witness, not through the lawyers. Because in Tale, Mukasa is said to have bribed Maumbe. When Intale is recording his affidavit, he's a leader, he looks for Maumbe, he says, Maumbe, did I bribe you? Because they said I bribed you. Maumbe said, which evidence? How come when I didn't vote? I was not even in Kawempe. I know, I'm willing to go to court and tell the court that I didn't vote and I've never spoken anything. I wrote those circumstances under which Maumbe comes. Now, the justice of the case is, should the court be requested to look out such a person in an election petition, which is an inquiry.
Okay, the submission of counsel for the petitioner was not to lock out the witness, but subjective it is already.
My lord, the prayer was
to strike out the second, and after that, it was the first one, and then it started
my lord, from what we had captured, first of all, the right to cross-examine is available to all parties. And
the prayer was to strike out the second set.
Yes, my lord, and those are the affidavits we are talking about. And the law is that they are not struck out preliminary at this stage. And my lord, I will now go to the last one before I address specifically that issue, because the PO is premature. And we are going to submit for why it is premature. But I would like to go to the last one, who is Chamber Nathan. So my lord, on the first two, Nkale Mukasa is not their witness, not subject to the PO. The second one didn't even swear. He's saying I'm not recanting because I've never sworn. That one cannot also be called a recanting until court listens to him. The third, who is Nathan Mwambuzi Chamber. My lord, this one is the one that falls under what we call recanting witnesses. Recanting witnesses. And recanting witnesses are not illegal. I want to submit on that. Recanting witnesses are not illegal witnesses. My lord, in highlighting that, I would like to say that courts have held that in the election petitions, like what we are dealing with right now, court is required to subject each allegation raised to a thorough and high level of scrutiny, and to be alive to the fact that in an election petition in which the prize is political power, witnesses who are invariably partisan might resort to telling lies in their evidence in order to secure judicial victory for their preferred candidate. Lord, that's what we are faced with in election petitions. It is an extension of the campaign. The campaign was ended, there was a declaration, and a new campaign has begun in court, where witnesses come with preconceived. So the jurisprudence of the country is that courts must examine each allegation. We are not arrogating sainthood on the respondent, and neither are the petitioners. My Lord, your brother, Honorable Justice Issa Ssenyonyi, in Kamwine Daphne, versus Tumusime Francis and 3 others, Kamwine Daphne versus Michael, that's High Court Civil Suit number 96 of 2021. In citing the celebrated case of Mukisa Biscuit, Manufacturing Company Limited versus West End Distributors, 1969 1EA, the court held, I will quote verbatim, for purposes of demonstrating to court that the criminal objection before court is not a criminal objection. It's premature. So far as I am aware, my Lord, that's page 6. Page 6 of the Kamwine Authority. And the second last paragraph is where I am. The court here noted that the question to be considered here is whether the preliminary objection raised is competent to be dealt with as such. The main principle governing criminal objection was considered way back in the case of Mukisa Biscuit, where court held that so far as I am aware, a criminal objection consists of a point of law which has been pleaded or which arises by clear implication out of pleadings, and of which, if argued as a prior point, may dispose of the suit. A criminal objection is the nature of a demurrer. It raises a pure point of law which is argued on the presumption that all the facts pleaded by the other side are correct. And my Lord, my emphasis is on this last part. It cannot be raised if any fact has to be ascertained. My Lord, before us, God has no evidence, has no proof of any tampering, any bribery, any coercion, any inducement of any of the witnesses. So that is a fact that must be ascertained by one person like me, a lawyer, standing and giving evidence from the bar when I'm not a witness, cannot amount to proof before court, because these are very serious allegations that border on professional misconduct. So this authority, which has been consistently cited and is still binding, says it cannot be a PO if there are facts that have to be further ascertained through eliciting of evidence, or if what is sought is in the exercise of judicial discretion. Now, what counsel for the petitioner wants court to do is exercise discretion between these two sets. Which one? My Lord, that ceases to be appealed. And we are submitting, my Lord, that the PO is not a PO and should be overruled and dismissed because the court be pleased. My Lord, the law provides remedies in these instances, and the remedies is what has been applied consistently, even in the authorities that is cited. As to whether the granting is real or not becomes an issue for determination. And then evidence is led. And when court is finally determining, guided by the nature of evidence before it, it takes a decision judiciously. I hope with us, I conclude by submitting that this court be invited. This court be invited to follow the binding decisions of the Supreme Court, which are stare decisis, in answering the question before it. In answering the question before it. And for brevity, my Lord, your sister on the bench, Justice Faridah in Uganda versus Ssenyonyi. In Uganda versus Ssenyonyi, in which she cited the Supreme Court decision of Okwanga Anthony. In which he cited the Supreme Court decision of Okwanga Anthony versus Uganda, Supreme Court, Criminal Appeal number 20 of 2000. In answering the question as to whether the evidence of a hostile witness, my Lord, these are hostile witnesses in law. One who does this and tries to change a position are hostile witnesses. And hostile witnesses appear every day when you are in court. You cross-examine the fellow and he runs from his other position and changes and say, I'm now ready to say the truth. That is not illegal. It is in fact kudos to lawyers and court for doing the right work to milk justice out of whatever situation is before you. Court says here, court in the Supreme Court. My Lord, it is on that authority that we shared with God. It's highlighted. And it was held that it is a settled legal position that the evidence.
Where are you reading from?
My Lord, page 3. On the throne of Ssenyonyi. Well, the expression hostile witness does not find what the court there was quoting. He is going to mean testimony of a witness standing to depose in favor of the opposite party. We must bear it in mind that the witness may depose in favor of a party in whose favor it is meant to be given through his examination, while later on change his view in favor of the opposite side. Similarly, there will be cases where a witness does not support the case of the party, starting from the examination itself. This classification has to be borne in mind by the court. With respect to the first category, the court is not denuded of its power to make an appropriate assessment of the evidence. Such evidence will become complete after the cross-examination. So once evidence is completed, the same testimony as a whole is meant for the court to assess and appreciate what facts. Therefore, not only the specific part in which a witness has heard or said, but the circumstances under which it happened can also be considered. I don't just quoting also that the reason why the precedents have encouraged when those occurrences arise to subject the parties to cross-examination is for court to appreciate the circumstances under which the instances do arise. With that, we would like to pray that court be pleased to overrule the objection because it is premature and the law provides for remedies on how to deal with the same situation.
Okay, before you sit, what about the recent court of appeals?
My Lord, yes, my Lord, and my Lord, we want first of all to associate counsels for the respondent with the same decision and invite court to follow the same decision. My Lord, we will go to page 'But in the same decision, court was of the view that a decision on how to treat the same can only be arrived at after evaluation.
What did the judge say?
So let me get the court of appeal decision on that. I don't read it here, but the frowning at the practice of lawyers was arrived at after a judicial inquiry, after cross-examination. You cannot at a preliminary stage say, for example, a lawyer influenced. A lawyer did this. In fact, in all the authorities, even in Akan itself, the witnesses are subjected to that process. And my Lord, just like I highlighted, there is Supreme Court guidance on that, how we deal with them.
What did you just say about how a trial court is supposed to deal with some specific
My Lord, just a moment. My Lord, I would seek guidance on any specific page that you will be directing me to.
My Lord, it's page 17 for page 17. Paragraph 58, 59, and 60.
Yes, my Lord. So, page 17 is there too. Possible approaches to dealing with affidavits of witnesses that switch sides and or recant their affidavits. Firstly, it is wrong and unprofessional for an opposite party to approach the witness of the other party seeking to turn the person into witness for his side. And my Lord, that is a statement of fact. My Lord, I'm saying it is wrong, but I'm also saying here, interpreting this, that this is a statement of fact, because evidence had been led to that. even in the lower courts, by witnesses. The only option available to him or her is to meet in court and subject such witness to cross-examination. Well, this is the decision here. Although I'm saying that there is a Supreme Court decision and we have a principle of stare decisis, and I've quoted that authority and given it to court. But in the wisdom here, there are options that are available. And that is Bakaluba Mukasa Peter, which is Supreme Court, on how to treat. And my lord, it was page 22 that I highlighted support. Yes, my lord. The deponent has to be, that's what the Supreme Court authority says. And my lord, the Supreme Court was speaking from the case of Nelson. Nelson versus the Attorney General and another, it's 1999, East Africa. My lord, it was unnumbered, but there is page 3. Where court, the Supreme Court, says evidence by defectors must be received with caution and should only be admitted in special circumstances. So it doesn't say that evidence by defectors acts like a Russian poison. Don't touch, don't see. No. It must be received by caution. And if it is to be admitted or relied upon, the Supreme Court stealing of Kwanga, I mean, who is right? So before you are no angels, my lord. I beg to submit.
Before we even proceed, my lord, in the current situation, while I believe they are premature, may lead to a miscarriage of justice, is we realize even the directions to this court on how the hearing is conducted. There is even space for the petition evidence of a witness who is saying, I never saw any African. Lord, if you look at the directions we're hearing under Rule 9, nine of the rules under the Parliamentary Elections Act, Lord, you realize that the process we are miscarrying the process because upon presentation, judge the consent of the parties under sub-regulation 2 will hear the parties on whether any of the parties are, that is sub-regulation 2, paragraph 8. You may receive written notice of an intention not to oppose. You may receive written notice that the petitioner wishes to withdraw the petition. My lord, you may record any facts which have been agreed by the parties. It's a process. After recording the facts, my lord, you may settle the remaining issues, if any. My lord, after that process, you give directions as to further and better particulars, which will be necessary to avoid surprise at hearing. Most important, my lord, you may give directions as to the evidence to be called at trial. Discourage if at this stage, when we went into detail, you know that strike out is evidence. When we went into detail, you know that strike out is evidence. But we stand also we stand a danger. If the ruling on these POs is to come at a later stage, probably we had more recanting witnesses. Yes, probably we had more. So it would be difficult on whether to bring in other people who are saying actually we will not. So I believe my point, the point my Lord is they are dealing with the premature, and this is an inquiry that is submitted. My Lord, in the case of Honorable Mama Babas, the Supreme Court determined that petitions of the nature and that was without any evidence before you even inquire. You've not started. Before an inquiry, you are jumping. Versus your Kaputam 7 and others who have participated with us here. We took a lot, there's a lot of literature discussing on whether that's election petition number 1 of policies. The nature of an election petition. And the finding was, it was an inquiry. An inquiry is an investigation. An investigation, you don't simply close out the information. That's what supports the lengthy submission of my colleagues. I submit that you find, my Lord, that their criminal point of law is premature. It should be over. It may cause a miscarriage of justice and a misdrive of these matters. That is also dangerous. And we are I'm obliged.
Yes, well, of course, I think the very first thing I make they are littered by misconceptions and misunderstandings of what my preliminary education was about. Let me start with the decision of Namo's. Now, my Lord, I have read that decision. And while my colleagues were submitting here, I got the feeling that we're reading from a different script. That decision, my Lord, is inapplicable to the current circumstances. Why? Number one, the Supreme Court did not. Now that's why you keep asking, wait, did not specifically deal with the issue of the anti-witnesses. It's not there. And let that have interpretation in the manner. And it did not make a decision on the issue of recanting witnesses. They are quoting a decision by interpretation. Secondly, my Lord, that decision did not consider anywhere Rule 19 for the advocate's professional conduct regulations. Not there. Unless again they have a different scope. Thirdly, my Lord, even if that decision had taken into account those two principles, the current decisions of the Court of Appeal would be the correct position of the law, and I'll tell you why. The current decisions of the Court of Appeal would be the correct positions of the law. The decisions as late as at hand. Why, my Lord? Because of the doctrine of concurrent or ordinate jurisdiction. My Lord, under Section 85(3) of the Parliamentary Elections Act, the Court of Appeal is the final court of appeal in parliamentary elections. It would mean, my Lord, that decisions of the Court or Supreme Court, yes, was the final court of Appeal. And those of the Court of Appeal now, as the final Court of Appeal, rank at the same level, under the doctrine of coordinate jurisdiction. My Lord, for that principle, I rely on the decision of Young versus Bristol Airplane, Young versus Bristol Airplane Company, 1944:1A. That decision, my Lord, when I'm quoting, has been quoted in several Supreme Court decisions. That's a bit too much. Firstly, my Lord, that is why that decision that I've just quoted of Nambi was referred to in Kenzo Alex Brandon on this exact subject, and the Court of Appeal gave a different approach. I'm sure Mr. Alex Uganda knows, since he says he had it. They considered that decision, my Lord, at page 11 up to page 12 of that decision. They looked at it, they found it applicable in the terms I am proposing. Question number 2, is this a people? Is this premature? Is this a premature? My Lord, it is not. And my friend's submissions on that point, I think, are because of the misunderstanding of what the people is. This people is simply that there are 2 affidavits on record. There is one in support of the petitioner and another in support of the first respondent. That is a fact that needs no further evidence. Point number 1. Point number 2, that the lawyers, my colleagues for the first respondent, have assisted these witnesses in preparing, understanding, explaining, translating, and these affidavits, filing these affidavits in court record is not in dispute. Because they say so in the affidavits, my Lord. They say, I have been helped by the lawyers. I have been helped by the lawyers. Those paragraphs are there, my Lord. And you see them. In the affairs of Mutundwe, Mutasa, and Jem. That fact, my Lord, is not in dispute and needs no further proof. And that is the nature of my people only. I'm saying you cannot have 2 affidavits on record. As simple as that. And those 2 facts need no further proof. Corollary to that, my Lord. I think I should also say this in passing. The submissions of Mr. Minister. My Lord, pleadings are closed. I'll give the decision arguing himself. Pleadings are closed. Mr. Minister, you argue this decision, but you are forgotten. Can I have this before? Versus to lead a purpose. My Lord, pleadings are closed when the answers are final. This is the decision of the Court of Appeal. Now, but when they talk about the facts in this week, I have just told you the facts that constitute my people. My facts are only 2. One, that affidavits are 2 affidavits from the same people appear on the record. That is the fact I am finding. They went into so many other things, but this is my fact. They went to many other things. The second fact is that these affidavits were prepared, filed, translated, explained by my colleagues. That one needs no further proof. My Lord, these two facts I'm talking about were prohibited in all of the authorities I cited. Whether it is Kenzo, whether it is Barbie, whether it is Akan, whether it is Nalukoola, the Court of Appeal is simply saying, don't touch. Don't bring second affidavits. Now, my Lord, at that point, they then came into what I'm submitting. They are saying, you can proceed this again. You can proceed this again. It is okay. That's what I am saying. That the approach is not for you. When you hear all of these things they have been saying, did I bribe? Did I induce? Did I do what? It is okay. Those things do not come to the record by way of a second affidavit. No. What the courts have told you, you wait for cross-examination, which they have extensively alluded to, and then you bring out all of those facts. Okay, you do not bring them by way of a second affidavit. And my Lord, on the question of hostile witnesses, witnesses do not become hostile in lawyers' chambers. That's section 153 that my colleague referred to. A witness becomes hostile when and is answering contrary to the witness, the party that brought them. You will not sit in your chambers in Mengo and say this witness is hostile. They must take it to court. No. They don't become hostile in chambers, in lawyers' chambers. They become hostile here in the dock during cross-examination, which is what I'm telling you, which is what the court of appeal has said. That is the approach. Take out the second set of affidavits, let the witnesses come to court, and they undergo all manner of tests through cross-examination by the court and by the other party. So all the things they went into, there is no proof of bribery, inducement, all of those ones are not my PO. All of those facts they will hear during cross-examination. My question is, you have two affidavits on file. The court of appeal has said second set must go. Then what do? You do what they are saying. Cross-examine extensively, test veracity and reliability in cross-examination, not by filing a second affidavit. My Lord, if Uganda alluded to the fact that Maumbe says, because Maumbe says he never signed an affidavit. All of that comes in cross-examination. Okay? It's when you find out, did you sign an affidavit? Says no. Did they approach you? No. You don't make them swear a second affidavit. You establish all of those claims during cross-examination. My Lord, in one of the students I gave you earlier, that's what the court of appeal said. I'll take you there, my Lord, if I may. This is my Lord Obonama that you have already there. My dear Lawrence Onama Obo. That was at page 13, paragraph 29. This is what the court of appeal says. Therefore, if he believed the people had indeed been coerced into deponing an affidavit against him, the course of action that was available to the first respondent, just like Mr. Nalukoola, was to subject Mr. Wahadira to cross-examination to establish the veracity of his claims. One of the approach is not to file a second affidavit. You do as they are acceding. You cross-examine. You don't file a second affidavit. My PO is that you have two affidavits on record, and the court of appeal has said no. Take out the second set. Then deal with the rest of the issue. I can give it to you. Now, my Lord, the issue of witnesses are free to become hostile. They are free to recant. This recanting has been there for ages. First of all, yes, it has been there for ages, but the court of appeal has told you it is illegal in Uganda. Clear. Okay, in all of the decisions I have cited, the court of appeal has told you it is illegal in this country. So it doesn't matter whether I've been here for ages in India, Tanzania, this court, this country has told you recanting is illegal. It does in certain terms. And that the other party is barred by law from approaching the witnesses of the other side. In no uncertain terms, the court of appeal has told you. Now, whereas, my Lord, witnesses may change testimony. For example, in cross-examination, I bring a witness and says weird things. Whereas counsel cannot control what the witness says in the box. There is something a lawyer can control, my Lord, which is the central point in this matter. Where a witness says, I want to say something else. I want to recant. That is right. But there is something a lawyer must do. These colleagues of mine ought to have known. When clients came to them and told them they want to recant, so they ought to know the law. They would have told them, wait, during cross-examination, sirs, we shall handle that matter. Okay? That is what Chief Alex President says that Mr. Uganda argued. It says that they ought to have known and told the witnesses that please, yes, we have heard you did swear, you were taken quarrel and everything else, but wait, during cross-examination, we shall handle that. Because my colleagues know the law that the Court of Appeal has told you, don't file a second affidavit, wait for that witness during cross-examination and ask all manner of questions. That the lawyer has no right to. In fact, it is an obligation to tell the client, please, let's not take this affidavit here. For that, my lord, I rely on the decision. That kind of lawyers, I rely on the decision of Myers versus Elmer. House of Lords, same situation. What is the House of Lords say, my lord? Because last time someone was saying, what if they existed? What if they existed? The House of Lords said, the solicitor, I'm reading about it. The solicitor cannot allow a client to make whatever affidavits he thinks fit, nor can he escape responsibility for careful supervision and investigation. If the client will not give him the information he is entitled to, or he insists on swearing an affidavit, which the solicitor knows to be perfect, like in this case under our law, my lord, what does he do? Then the House of Lords say the solicitor's proper course is to withdraw from the case. That's how the same situation. I've highlighted other areas that are clear in this point. So it doesn't even arise that as the lawyers, we are not the ones who approach them. The law bars even Mr. Nalukoola. And I told you, my lord, last time that is interesting. If you look at those affidavits, they were all translated by somebody from Mr. Nalukoola's law firm. And the court of appeal has told you, whether you are the respondent, whether you are the lawyer, you are banned. Don't touch the forbidden fruit. As just second and the policy in hand. Possible. So, my lord, it cannot even obtain in this argument that Rule 19, we have not moved lawyers in use for that. No. The prohibition is against both the first respondent and the lawyer. The prohibition is against both the client and the lawyer. Now, on the issue of how do you approach this scenario, my colleagues have contemplated all them to tell you whether they were bribed. My lord, Atan has told you, okay, and I have argued that under the doctrine of concurrent of all the jurisdiction, that they should be at the same level as in others. Even if you have said something else which doesn't. Atan tells you, your lordship, that what you do when you are faced with this time, kindly strike out the second minutes. None of the decisions, my lord, I have quoted from the Court of Appeal, including Atan, tells you that first listen to them. No. None of them says that. No, not single one of them says first listen to them to see what they are saying, then strike out. No. It tells you, once you see two affidavits, strike out the second say. Then let the witnesses come to the box. Okay? Because, my lord, it is not only through a second affidavit that this evidence my colleague is referring to. It's the only way it can be received by the court. No. It is not through a second affidavit that the evidence they are talking about can be received by the court. It can be received in viva voce through cross-examination. So, my lord, what I'm saying that the concept of a second affidavit doesn't appear anywhere. And it's not the only way all manner of evidence they are talking about to prove whatever they want to come to the court. It can come to the court and it will, and the court of appeal has told it to come to cross-examination, not in other ways. The affidavit from Ssenyonyi, I think my colleagues misunderstood my opinion on that point. I did not say Mukasa Recanting. I only say that Mukasa procured the commission of the illegality we are dealing with. There are two persons who recanted, Chamber and Nathan. Chamber James Mwanguzi and Nathan. From Mukasa, my argument was that if the court is convinced that this was an illegality, he clearly, and the deponents clearly say he is the one who brought them into the illegality. I am saying, what sense of having participated in that illegality was out of state. And I've introduced that illegality to you, and my work cannot be somebody. My colleagues have also referred to decisions of the High Court. right from the beginning. I don't want to. I don't want to. My lord, I don't want to make my religion a study of the law of Christian. But when we are here discussing what of appeal decisions, I need to explain kind of it. Now, my lord, the whole Kawanga Ssenyonyi that's not that way from the in Kawanga Ssenyonyi, what's the attorney general? Even if this court had an opinion different from Atan, different from Brendan, different from Nalukoola, it cannot say it. In Ssenyonyi, the Court of Appeal disregarded the two decisions of the Supreme Court on the same matter. The lordships in the Supreme Court saying the Court of Appeal was not saying that even if they had a different opinion. So these decisions of the High Court, those ones are out. Even if my lord tell a different view, when Alex from the Government says do this, that is it. When Atan says do this, that is it. Even if you want a different opinion. And that matter that just referred to also was captured in Young versus Mr. The story point. So, my lord, we have made decisions on the Court of Appeal that are binding on the court on how to approach this matter. And I've distinguished and I've taken away the decision of numbers, and even if it were there, it would be accepted. So, really, we should not be entertaining decisions of the High Court. I'll give you the decision. How about this issue of we shall handle the people on it? We shall handle the people on it. Why? Points of law, my lord, are taken at the earliest. My lord, there's a decision here. I don't know if I have it in my file here. In election petition, take it immediately. I'll refer to it, my lord. I remember it in my head. It is therapy, first Attorney General, 1997. It says when in an election petition a people arises, you immediately deal with it. To avoid, they say that decision, confusing issues. So let us not confuse issues that my colleagues are saying here. First here who bribed them, whether they were coerced. The second after that is here, take it out. All those other things we shall hear. As we refer to Rule 17 of the Advocates Profession of All Accreditations, Rule 17 does not allow you to file a second affidavit. It does not allow you to file a second affidavit. It tells you, yes, you tell court what happened. So you tell court that Mahumi was bribed or coerced. That's fine. In cross examination, not by you filing a second affidavit. You still have the duty, even during cross examination, to tell court what happened. Okay? But you